I don't think I need to introduce myself, but one thing I would say is that I am not an expert, and certainly not an expert in forensic podiatry. However, I am a private practitioner in the UK, and therefore it's necessary to be aware of forensics and legal issues. So for this presentation, I'm going to outline a definition, talk about a case history, something that could happen to any clinician, that happened to me, a brief overview of forensic and legal work in podiatry, and the 4 facets of forensic podiatry specialisms and how we do it, and then perhaps with a conclusion. But the main message I want to get across to anybody, whether you're a podiatrist or a physiotherapist or a pedorthist or a medical professional particularly, and I use the word medical in the broadest sense, is to record everything you do and why you've done it. And I hope by the end of this presentation, you'll understand why I'm saying that. So I'm going to start with this picture that you can see on the right-hand side is a burnt out house. And it was an ordinary night in March 1992 for Marilyn, a 40-year-old single mum, and her teenage son, Nicky. He had been in his bedroom for some time when she went to bed, and they both fell into a deep sleep. Too deep for her to notice 3 or 4 hours later, the acrid smell of smoke drifting into her room. In a perverse way, it was fortunate that neither of them woke up to the horror of being consumed by the fire that now raged through their house. They died from smoke inhalation. 21 years later, the person who started the fire was convicted of manslaughter and sent to prison for 15 years. But more of this later. We're looking at forensic podiatry, so let's just get a definition. Any definition will do, because forensic is related to the law. It's related to an argumentative exercise. And now these days we refer, if we think about forensic, we think of forensic science and so on. But there are people who are, for instance, forensic accountants and so on. So we're applying this word forensic to mean a science that looks at legal issues and, in this case, identification. One person who stands out for me in forensic work is Professor Wesley Vernon. And I've got a quote here from Wesley from the book he wrote with McCourt in 1999. And the quote is from 2009. So the definition of forensic podiatry is the application of sound and researched podiatry knowledge and experience in forensic investigations to show the association of an individual with a scene of crime or to answer any other legal question concerned with the foot or footwear that require knowledge of the functioning foot. So that pretty much says everything about forensic science, in that it's about identification. And Wesley goes on to say those who specialize in this field need to have gained knowledge and experience in podiatry and also in forensic science and practice. Okay. So it's all about identification. The vast majority of the involvement of podiatry in criminal law is identification. Not entirely all, but it is the vast majority. The identification of the person is the same person in one situation, the same as in another situation. Of footwear, does this footwear, shoes, boots, insoles, footprint, impression on a carpet, impression on a mat, belong to the same person? Has someone else worn this shoe, for instance? And of the scenario, identification of the scene, does this fit with the context of the crime? And in asking those questions, we have to think about the balance of probability. a court of law is only satisfied on evidence that a fact or event occurred. In other words, there has to be a balance of probability that will sway a court of law. So what is required of forensic and legal work? Well, for a general practitioner such as myself, and the vast majority of podiatrists listening, the only thing that we really need to take into account is good record keeping and the ability to defend our actions as a professional clinician. If, however, we go into specializing in forensic work and legal work, the two go together, we need to be referenceable with specialized knowledge. In other words, the court needs to see that we have the knowledge that we are using in the field. And that, of course, means that we need to be experienced in the field of forensic podiatry or forensic work and forensic identification. And we have to have a knowledge of police and court proceedings. That's essential. If you're going to stand up in court, you need to know how the court works. And this, of course, means that you have to have basic skills and knowledge of podiatry, as Wesley Vernon pointed out in his definition. There are 4 facets to forensic podiatry. Let's say 4 main facets to forensic podiatry. There's footprint analysis, forensic gait analysis, footwear analysis, and podiatric record analysis, podiatric records. So we're looking at the way somebody walks, the footprint they left behind, what was happening with the footwear, and does this meet with what we know of the patient from their records, the paperwork. So firstly, footprint analysis. It can be, as with a fingerprint, the striations of the skin on a surface. So barefoot walking will leave marks. It can be contours. Contours, the shape and characteristic of the foot and how we measure them. And those contours can be from a footprint, such as a wet footprint on a surface, to the contours of a surface that has been deformed by the pressure of the foot. And we can do this by pressure mark mapping and analysis. So contours related to the gait as well as to the morphology of the foot and the individual. And always it's a comparison. The same applies in gait analysis. It's a comparison. And we are looking at movement characteristics in walking, running, any activity. We're looking at characteristics that will pick out an individual or give us a balance of probability that that individual has those characteristics. So individual characteristics of gait and circumstance related, e.g. to a footprint, to an insole, to a shoe, to functional anatomy, and to a crime scene, to an individual. Footwear. The physical size and shape of the footwear, how the footwear has been deformed, wear patterns on the sole and the upper, the contours of the sole, the outsole, and relate that to gait and functional anatomy. And again, comparison. And then there is podiatric records and medical records. So the history of injury, surgery, deformity, dysfunction in an individual that we can compare. And other individual characteristics such as lifestyle, etc. And this would all be used to identify by comparison. So how do we do it? Well, as I said, for footprint, it's like a fingerprint. We're looking at the striations, and this now is done by digital software. We have topographic imaging and analysis for the contours of the foot. We can take photographs, take laser images, etc., and produce images of the topography, the lumps and bumps of a footprint. And then, of course, we can look at pressure and movement patterns, and we can make a judgment as to what the pressure mapping tells us in terms of comparison. And this, as you will gather by now, needs good clinical and biomechanical knowledge and sound clinical reasoning. So looking at gait analysis, it's interesting. This is an article from the British Sun newspaper in 2018 saying that Chinese authorities have begun deploying a new surveillance tool called gait recognition, which thwarts even the cleverest disguises by identifying your stroll. It was a bit far-fetched in what they were suggesting, but nevertheless, this is how clever algorithms, etc., have become in gait analysis. And of course, we can deploy these sorts of tools in judging an individual's gait. And there's various gait analysis software and tools that we can use to look at somebody's gait and compare it. And once more, we need good clinical and biomechanical knowledge and sound clinical reasoning. And in this case, we need a very sound knowledge of how gait works and how to analyze it. In footwear, it's usually looking at the physical shoe. So it might be a sock or some other type of footwear, but from the point of view shoe and boots, we're looking at how the upper is deformed, how the insole is deformed, what the wear patterns, what the contours are, what the pressure markings are, and all subjective to anatomy and gait. We use laser scanning and all sorts of other different tools to check this sort of thing out. And indeed, in some cases, clever enough to know if another individual has worn somebody else's shoes. And they only need to wear the shoes for a short period of time, and we can see wear patterns overlaid on another. And again, good clinical and biomechanical knowledge and sound clinical reasoning. And the patient records, the history, and so on, and comparing them to medical records and case history were often used in the court of law to identify somebody by those characteristics. Working in the law, sometimes we will be called in as a podiatrist to a prison, and I worked at this prison. It was a female open prison for some years, and I'll just share with you a couple of things that as a podiatrist I could bring to the prison service and the healthcare of the inmates. I identified self-harm that had not been shown to any other professional in the prison because they were always covered by footwear, and so I could inform the authorities of an inmate who was self-harming. We had two twins come into the prison who claimed that they couldn't speak any English at all, and that they both had biomechanical musculoskeletal problems and couldn't work. They came to say they were sent to see me, and sitting in the waiting room, I overheard them speaking fluent English. And also when they told me what the symptoms were, they didn't match anything to do with their characteristics. So we sent them back to work, which was part of their purpose of being in prison. And of course, you can often tell that somebody is abusing drugs. Drugs in the prison service is a real problem. The other thing I want to point out about this is that, as I said, podiatrists, ordinary podiatrists can end up in a legal situation. And this is a case history. Litigation is becoming more common. This was a podiatrist, a colleague, who prescribed 15 millimeters of felt arch supports and strapping for a 30-year-old lady who was complaining of pain in her left knee. This was a diagnostic strapping. He wanted to see if controlling the pronation worked, which was very reasonable in my view. He or she applied them to the feet and strapped them in place. This was to give temporary relief and as an indicator towards further treatment. But none of this was written down in the records, and none of it was transmitted to the patient in any recordable form. So 2 days later, on a night out, the patient fell and suffered a POTS fracture of her ankle. She claimed it was the felt, the 15mm felt and strapping that had made her unstable, and therefore the podiatrist was liable for her injury. The lawyers acting for the podiatrist's professional indemnity insurance company settled out of court, despite the admission by the plaintiff, the person concerned, that she was wearing high heels and had been drinking. And the reason why the lawyers settled was because the podiatrist's records could not support the defense. In other words, he hadn't written anything down. He hadn't said what he was doing or why he was doing it. And that cost his indemnity insurance a few £1,000s. So the moral of that story is keep comprehensive notes. There's always a chance that a patient will be dissatisfied with with the treatment you give and seek legal redress. Don't just write down what you've done, explain why you've done it, everything that you have done, and what you expect the outcome to be, particularly if you are issuing foot orthoses or specialized treatment. Always record what advice you give and how it was given, and written advice handed to the patient is always preferable. You must be able to justify your actions. It's not just forensic podiatrists that end up in court. It can happen to all of us. So, back to 1992 and the fire. The mother and son. Let's get to the who, the why, and the timing. So, from my point of view, the police first contacted me in 1992, just days after the fire. The house, by the way, was not far from my practice, only a few hundred meters. They had a suspect and had found my practice phone number in his diary. They wanted to know if I could help, quote, put him in the area near the time of the incident. All I could say was that he had kept an appointment with me a couple of days before the incident. I explained that he was having purpose-made orthoses, which I'd taken a cast for, and they asked me to keep any records, casts, etc. That was 1992. They then contacted me in 2012, late in 2012. They had news that a man fitting their suspect's description had returned to the country under another name and asked if I could help identify him. They had never given up on the case. They'd never closed the case. And when an individual was flagged up coming in with a false passport that was like him, they got him. I told them I could help. The next contact was in early 2013 from a detective who asked if I could say, with some degree of certainty, degree of probability, that their suspect was the same person as my patient, and therefore that he was in the area at the time of the crime. Obviously, he was trying to say he wasn't in the area at the time of the crime. If their suspect, I said to them, if their suspect has a congenitally short fourth metatarsal with associated skin lesions, I could identify. I still had the casts, I still had the orthoses, I still had my records, and I still had my appointment diary from 1992 because they'd asked me to keep them. So in the balance of probability, there was very little likelihood of someone with the same appearance, the same ethnic origin, having the same congenital foot problem, would be in the area of that crime at the appropriate time. I heard nothing until after the trial. The same detective rang to say, "Thank you for my help." I asked, "What help?" She said, "I can't tell you in detail, but let's just say we got a confession." So there's the fire again, and the person concerned was sent to prison for 15 years for manslaughter. He had escaped to Pakistan before settling down in America. and he'd come back into the country on a false passport, and that was traced him to Texas, and the American authorities helped with the case, and he's still in prison. I checked about congenital short fourth, and there was quite a lot of information with things like femoral hyperplasia, etc. You can look all these up, but the one thing I couldn't find was any reference to the incidence of congenital short fourth metatarsal. So if I'd had to stand up in court and talk about short fourth metatarsal, I couldn't say what the incidence would be, and I couldn't actually be sure of the balance of probability. So here's some further reading. There are books on forensic podiatry, forensic gait analysis, and so on. And there are places, particularly in the UK, where you can get information about forensic podiatry. I think there is a course in Huddersfield. I'm not sure whether it's still running. It's a master's degree in forensic podiatry. And if you're interested, there's some help for you. So in conclusion, and my main conclusion, if you're going to commit a serious crime, don't do so in North Staffordshire or Britain, for that matter, because you will be caught eventually. And we all need to keep an eye on the legal issues of what we do every day. So keep good notes. You never know when you will be needing them. Thank you.